Dr. Lewis, you remain under oath.
Dr. Lewis, I just have a few more questions for you this morning. You had just testified that you based a majority of your opinion on Mr. Chen on his personality profile. Is that correct?
Yes, his personality profile, as well as just like any other mental status at the time of the offense type of evaluation, there's certain types of questioning that you ask the individual as they walk through various acts or allegations. So this is what I conducted is no different. The hundreds of mental status at the time of the offense evaluation that I've done in the past. So I think that from the question that you're asking, it appears that you may not have knowledge of how mental status evaluations are conducted, which would be appropriate. So yes, I look at the personality profile, but there's also a specific type of questioning that you ask the individual.
In 3 hours?
Yes.
Okay.
And you review the evidence that's been collected, which is the discovery. So I looked at the things in the discovery as well. So testing, interviewing, and also the discovery. It is very, very typical in terms of best practices in forensic psychology.
You testified that you did not issue any formal diagnosis for Mr. Chen, is that correct?
That is correct.
But you just mentioned psychopathy and sociopathy.
Right, those are not necessarily diagnoses. Those could be personality profile types. So that's what I'm looking for. That's what I'm looking at in terms of your characterological function. So those are not diagnoses. So a diagnosis for something like that would be antisocial personality disorder. But psychopathy and sociopathy aren't a diagnosis. They are labels, or they are labels that tell us something about how the person's personality profile is, but not necessarily a full diagnosis. For example, you won't find that in the DSM-5.
Oh, the DSM-5. What is the DSM-5?
It is the book that we use that basically lists every mental disorder and their characterization of each one. So, for example, you will see something like major depressive disorder will be in the book. And there it says that this person has this, and that. And you use that manual in order to give someone a formal diagnosis.
Why did you not cite to the DSM-5 in your memorandum?
I don't believe it was necessary.
Is
I'm not sure how that would be necessary.
Based on your opinion, is Mr. Chen a psychopath?
No, he is not.
Based on your opinion, is Mr. Chen a sociopath?
No, he is not.
What personality profile does Mr. Chen have that caused you to come to the conclusion that it is highly unlikely that on November 23rd, 2022, he was unable to form the requisite mental state of this offense?
Just like any type of other mental status type of evaluation, I reviewed what his psychological or emotional functioning is, and what I found was there was a potential history of childhood trauma, there was depression, anxiety.
Dr. Lewis,
and you mentioned before.
I'm sorry to cut you off, Dr. Lewis. Hang on just a second, okay?
Jurors are walking by, make sure they don't hear anything we're talking about.
Dr. Lewis, you can continue with what you were saying about the personality profile of Mr. Chen.
So I was saying that he potentially has a history of childhood trauma. He experiences symptoms of depression and anxiety. He's younger than 25 years old. There's no known legal history that I found. That's why I asked you if you found any charges in terms of violence or intimidation. There's a history of misbehavior within the school setting. So those are all the things that I put together in terms of over the course of evaluating him. So there isn't a particular name, so to speak, of a profile. It's developing a profile who this person or individual is. And you compare it to, as you mentioned, something like a sociopath or a psychopath. You would expect different information to be in the actual profile.
What does potential childhood trauma mean?
Well, the psychological testing revealed that there was likely a history of trauma. And then when he was having certain instances during his childhood, a professional like me, and perhaps others, would likely characterize some of those incidents as abuse. However, Mr. Chen did not characterize it as such.
Mr. Chen said he wasn't abused,
Correct.
but you think he was.
However, he described the incidents that he described, most professionals, and like the others, we described it as a form of abuse.
Well, did he describe them, or was that questions in his testing that you gave him?
During the interviewing, he told me about his childhood during the interview, so he described them.
Were there questions on the test also related to childhood trauma?
Specifically childhood trauma, no. The testing was asking about, basically what the testing does, it's not face value. So it asks questions that may appear to be innocuous to the person who's answering or to the examinee. However, based on how he responded in the testing into the interpretation suggests that likely he has experienced trauma in the past, because he matches how other people who we know for a fact has experienced trauma is how he responded. So what we do is we do comparison groups. So we're comparing how he responds to items to how others who we know are known to have certain disorders or certain life experiences.
What was that childhood trauma that he denied having, but you found that he had based on what he was saying?
The childhood trauma is not categorized as trauma.
This is where it goes too far.
Okay.
I also think, Judge, at this point, we can get into it later when we get in. If the witness is allowed to testify further, he is recognized as an expert, and Mr. Josh wants to lay the foundation, you can ask him about the specifics later. So sustain at this point.
You'd agree, Dr. Lewis, that a majority of people with childhood trauma don't murder other people, right?
Absolutely. And I would never suggest that that would be an excuse for any type of law breaking.
Would your opinion change if you would have spoken with former friends of Mr. Chen that would tell you that they were scared of him?
That would be speculation. I don't know if it would change or not. It would depend on the veracity of the information or the details of the events that his friends would say. So if there's information that's there, I'm more than willing to listen and to hear it. And yes, my opinion could potentially change. However, I have no way of knowing that until it happens.
Well, some experts would have interviewed people.
Absolutely. They absolutely would have. Yes. I think that is very much a common, I would say a common practice for some. However, it is not necessary or mandatory in terms of best practices, particularly not for mental status at the time of the offense or mental state type of evaluation. So I do certainly agree with you that that does happen, but it's not necessary.
Why did you not come to Chattanooga to see Mr. Chen?
Because by the time I was available, he had been moved to Nashville. I didn't get clearance to even do anything until December 17th. And I was away on holiday December 16th through the 20th. And then I went out of the country from the 23rd or 24th until January the 3rd. And so I wasn't able to see him until January 7th. By that time, he was moved to Nashville, which is where I went to go see him.
Well, what about January 4th, 5th, and 6th?
Ma'am, there's no way I could have done that because I took a 24-hour flight from South Africa. So I need to rest.
All right, Mr. Weiss, at this point, we're still trying to decide whether or not we'll be qualified as an expert. Does the state object to be qualified as an expert?
Yes, Your Honor.
State your reasons why, please.
Your Honor, Dr. Lewis has he was licensed as a psychologist in 2021, so he has several years of experience as a forensic psychologist. Okay, I apologize, in 2021 in Virginia, 2020 in the state of Georgia. Of course, he's not licensed as a psychologist in the state of Tennessee. He, in fact, probably has expertise in some type of psychology, but having an expertise in some kind of psychology does not mean that you have an expertise in a defendant's mental state at the time of a criminal offense. A podiatrist does not have an expertise in forensic pathology, even though they're both medical doctors. So, no disrespect to Dr. Lewis, but as you go through, as we did, Dr. Lewis's resume, there is hardly anything in the resume or in his memorandum that has to do with reliability or trustworthiness of his findings as it has to do with the defendant's mental state at the time of the criminal offense. There is hardly anything. There is a lot regarding a defendant's competency to stand trial. That is not what we are here on. This expert cannot testify to toxicology. He is not, and I don't think this will be contested, he is not an expert in toxicology, which is apparently a primary issue of what he would opine on is the defendant's substance use on November 23rd, 2022 that he has no facts or information on except for what Mr. Chen told him. So he has no basis of knowledge. He is not an expert in the field of toxicology. He is not an expert in pharmacology. Sorry, Judge. Pharmacology. He is not a medical doctor. He has not presented enough facts and evidence of which he based his opinion on the defendant's mental state at the time of the offense. And in fact, Your Honor, the state is more confused after hearing his testimony because the defense alleged that the argument was diminished capacity, to which the expert adamantly denied that he was arguing diminished capacity. We now have a personality profile, childhood trauma. There's been nothing on the record that would establish that this expert should be qualified as a forensic psychologist as it relates to a defendant's mental state at the time of the offense. Moreover, he has not had enough time to speak with the defendant. He has not done his due diligence in checking the defendant's records, speaking with the defendant's family members or friends, and due to the fact that he's had the discovery since December 17th, it was on, quote, holiday and in South Africa for a majority of the time thereafter, he has not even had enough time to adequately go through discovery and make any type of finding such as this in this case. So we do object to this witness being qualified as an expert.
I do think the bar, there's some standard, obviously, for letting an expert testify. I think that it's whether or not some specialized knowledge might be helpful to the finder of fact in this particular case.
seems like perhaps he hasn't had the depth of experience that other experts have testified. Yeah, I don't think he has that yet. I don't think there's anything that's disqualifying as far as the weight that should be given to his opinion. That's certainly something we can talk about. But as far as again, his qualifications are concerned, as far as him being able to give an opinion, we're doing all this for the record. His testimony's already been deemed to be inadmissible, but I want the record to be complete. As much information as possible about Dr. Lewis. So I will recognize this witness as an expert in the field of forensic psychology. Mr. Washington, thanks for proceeding.
Before proceeding, Your Honor, I just want to clarify for my questions. Is the court finding that there was a violation of Rules 12 or 16?
No, I'm not finding there was a violation in the sense that a deadline was missed. I do think that, if you want to clarify my ruling, there are actually two aspects to it. The first is that it's clear that this expert's services for this purpose, for what we're talking about today, the defense felt it became necessary after a recent hearing last month where the monster exhibit was admitted, and there was some concerns about that, as well as the medical examiner's testimony going to premeditation. And so I think that based on the timing, so that the state is not unfairly surprised, the workaround that the court is crafting removes the major, if not the only reason that this witness's testimony on this issue was represented to this court was needed. So that's one of the reasons being excluded, is that the state, I want to avoid the unfair surprise that Rule 12.2 contemplates, as well as give the defense a fair shake, as he described in voir dire last week. So that's one of the reasons. The other is that I don't think that the opinion as written qualifies as something that would be substantially helpful to the jury. When Dr. Lewis wrote that it's highly unlikely that Mr. Chen possessed the requisite premeditation, I do find that there's a degree of speculation that is not going to rise to the level of where his opinion would be helpful. And also, I guess I can point it out now, that during Dr. Lewis's testimony moments ago, he talked about the great weight that he gave to personality profile type. I mean, it's pretty clear in case law that personality type is not something that's even relevant to a defendant's capacity to form a mental state. It's pretty well established. So there are numerous reasons that this witness's testimony has been excluded from this particular trial at this particular point. Those are the reasons. Not a 12.2 violation. Again, I don't think there was any bad faith. I think this is the way the circumstances unfolded. I'm not finding that the defense acted unethically in any way. It's the way that it unfolded, the short time frame. Yes, sir.
I'll need
So it looks like you got the draw. Just kind of let them know. Let them in. I'm going to have to start from scratch. If you could text Dr. Lewis and let him know that we've had some technical difficulties. I'm about to let him back in. Dr. Lewis was there just a moment ago, now he's not. There we go. Dr. Lewis, sorry about that. We're going slow for lots of reasons, but I'm sorry to say that sometimes technology, this court moves at the speed of technology sometimes. Well, a lot of it's user error. Hopefully we solve that for now, okay? So I believe Mr. Weiss can ask some questions now.
Hi there, Dr. Lewis. May I have it over?
Yes.
Well,
Can he see?
I don't know if WebEx will operate with overhead at the same time. No, it's either video call or overhead.
Can I try work around, Judge?
Yes, sir.
Unless the state's going to object, I guess it doesn't matter. Dr. Lewis, I'm holding what you sent to my office as a curriculum vitae. It says Douglas E. Lewis, Jr., PSYD at the top, and the top right corner it says REB.9.24. Is this your CV?
Yes.
For the purposes of this hearing, the defense moves to enter the CV of Dr. Lewis into evidence as Exhibit 1.
Yeah, for this hearing, not to go back to the jury. Exhibit 1.
May I approach you?
Yes, sir. Feel free to move on the court.
This is the first CV you sent us or the second CV?
Second.
Okay, my CD says revised 924 is the one.
That's right. Dr. Lewis, I have a letter here from Regina Lewis at the Board Administrator at the Board of Examiner in Psychology. It's dated December 17th. Was this letter given to you authorizing you to practice law temporarily in Tennessee?
Practice law, Judge?
I'm sorry.
Practice psychology.
Practice forensic psychology.
To practice psychology, yes.
Defense moves to enter this as exhibit number 2.
Exhibit 2.
Dr. Lewis, I'm holding in my hand a 7-page report, or memorandum rather. It says the Honorable Boyd M. Patterson, the top, dated January 11, 2025. Is this your memorandum pertaining to expert testimony regarding Jason Chen?
Based on what you described, yes.
Defense moves to make this exhibit 3.
Exhibit 3.
All right, Dr. Lewis, I want to ask you about the methodology that you used in this assessment. What validated psychological tools did you employ in your assessment of Jason Chen?
The psychological tools that are both valid and reliable are the TOBRA, the TSI-2, and the PAI, broadly and well-known instruments.
Are there, if you had more time to spend with Jason, are there other tests that you would have performed?
No. I mean, certainly there are numerous tests that we have at our disposal, but I don't think that would have been necessary. In fact, a lot of mental status at the time of the offense evaluations don't use testing at all because psychiatrists and psychologists perform. So a lot of times testing is not even used.
Are the methods that you use consistent with the guidelines recognized by professional organizations like the American Psychological Association?
Yes.
And you don't have to go through it, but are you able to cite research and case studies that support the evaluation analysis that you did on Mr. Chen's or Jason's psychological state?
Yes.
And is it relevant to premeditation?
Directly relevant to the issue of premeditation, just like most legal questions, there's nothing that's going to directly load on any type of legal issue. However, those are tools, yes, that are used to answer some of the legal questions and controversies that emerge.
Do you believe that you were provided all the relevant materials, including evidence including evidence to ensure that your assessment is objective?
that is objective, yes, I strive for objectivity, but as I mentioned earlier, with the introduction of more information or data that's objective, my opinion could change. However, based on what was available to me, as I mentioned in the memorandum, that is how I form those are the bases of how I form my opinion.
In your opinion, you say when to a reasonable degree of psychological certainty. What does that mean in the context of your opinion?
That means just like in any type of psychological science or practice, it is highly likely that what I'm saying is correct. However, when it comes to behaviors, actions, etc., we cannot say definitively anything. So that is what that means. That says that means that given the resources that I've been given, also the evaluation, the psychological test, etc., that to the highest degree to which is possible as a psychologist or a psychiatrist, this is what my opinion is.
Why?
However, we can't say anything definitively.
Well, that's my question is, why can't you say this, your opinion with certainty? Absolute certainty.
I am certain of my opinion. However, to say absolutely certain, I would have had to be in the room when these things were occurring, which none of us were. So I can't say this is absolutely what happened. I cannot say that because none of us can say that. However, based on the information, the data, the testing, the evaluation, it is highly likely that the opinion that I reached is the accurate.
Would you characterize your opinion as based on speculation?
No.
Why not?
Because I used and reviewed all the evidence that was in the discovery. I also conducted psychological testing. I interviewed. I reviewed his legal history, again, the things that are in the documentation. So speculation alone, based on my understanding, would be not using any form of evidence, not trying to use any type of objective psychological testing that's both valid and reliable. Those type of things, I think, I would characterize as speculation. However, when you use a multi-method approach, as I did, I would not characterize my final conclusion as speculative.
Did you make any assumptions that was unsupported by the evidence informing your conclusion?
No.
So can you explain to the court how your psychological insights from your evaluation into the mind of Jason Chen are relevant to the legal question of premeditation?
Okay, so premeditation is arguably something about one's mental status or mental state during the commission of an act. So just like any other mental status related evaluation, I am assessing and evaluating not only what came before, during, and after the act, but also I'm also looking at the personality profile of the individual. So I'm using all those things in order to answer the legal question. Typically, again, when it comes to legal questions like competency to stand trial, like mental status at the time of the offense, violence risk, etc., there's no legal question that psychologists or psychiatrists can directly answer in the way that you all are trying to characterize it. What we do is we use all the information that we have available, data, interviewing, observations, testing, etc., to answer the legal question. But it's not like A plus B equals C. That is not how these things work. Like, for example, there's no real test of premeditation. There's no test of mental status at the time of the offense. We use the information that we have and the testing and the level of questioning and training that we have to make to give the court answers to its controversy.
So sticking with the premeditation, particularly in cases with premeditation or where you're dealing with intent, can you elaborate on the specific experience conducting those types of forensic evaluations?
So those type of, I actually am in the middle one. I have one that I'm doing that has to do with the intent or the case element of intent in Virginia. And in those type of cases, we're looking at one's functioning behaviorally, socially, and intellectually or cognitively in order to make determinations about one's intent. For example, it was posed earlier about his reasoning and critical thinking. If someone, for example, has an IQ of less than 65 or less than 60, there are certain types of crimes without the assistance of another person, you know that they would not be able to do because they don't have the level of forethought or thinking. In terms, that's an easy way of kind of understanding it. IQ or functioning in terms of their cognitive functioning is something where we would be able to answer that type of question.
So, can you explain your role as a forensic psychologist and how it's distinct from a psychiatrist or a general clinical psychologist in assessing premeditation or intent?
A forensic psychologist is a clinical psychologist who has specialized or specialty training in forensic psychology, meaning we have gotten some type of legal training in that we understand how to understand or know how to interpret certain statutes, and we also apply psychological principles to legal issues. For example, as I mentioned before, the idea of competency to stand trial, mental status at the time of the offense. These are legal issues. However, you need a psychologist or someone with that particular training in order to answer those questions. So we're different from, a forensic psychologist is different from a psychiatrist because a psychiatrist cannot issue testing. Usually their training in forensic is not as comprehensive as it is when you are studying to be a forensic psychologist. And we're definitely different from a general practitioner because general practitioners are there to treat and evaluate mental disorders only. They don't have the legal piece, the legal understanding. For example, I had 2 to 3 years of didactic instruction about cases that involve mental health or psychological issues.
What methods did you employ in forming your conclusion about Jason Chen's mental state at the time of the offense?
I reviewed the entire discovery that was made available to me. I interviewed Mr. Chen extensively, not just questions about his personal history, but also violence risk and also sexual violence risk. Again, those questions were not all face valid, meaning there were times where an examinee would not know why I was asking the questions that I was asking. I also administered 3 psychological tests that are both deemed valid and reliable within our field.
So, in regards to the assessments that you did on Jason,
Sorry about that, Mr. White, for shuffling jurors around as far as figuring out when to do that, I should say. Please continue.
let me start over. The question is whether, right here, let me say this. Can you explain the psychological concepts of emotional regulation, impulsivity, and how they're relevant in this case?
So emotional regulation and impulsivity are important to this case because often people who commit murder or other heinous acts of violence, it tends to be in a heightened state or what I call affective aggression or violence. So someone who has trouble regulating their emotions or someone who is quick to anger and also is impulsive, they are likely to engage in behavior without thinking. And a lot of times, our jails and our prisons are filled with people who have committed acts out of being anger, not thinking, impulsive. So emotional regulation and impulsivity are two, in my opinion, major factors in most crimes when it comes to aggression and violence.
So one of the tests you did was, is it called TOBRA? How do you pronounce it?
It's called the TOBRA.
TOBRA. And you conducted the TOBRA with Jason Chen?
Yeah.
How did his performance in this test inform your understanding of his cognitive capacity for planning the protocol?
Well, the reason why I issued that test is because someone who is highly intelligent will create a different type or may slightly change the way that we characterize in terms of the profile. Because someone, and so I needed to know where he failed in terms of the Bell curve, in terms of intelligence. So it's not a test of intelligence, but one of reasoning and critical thinking. And so if he has scored really high on there, that may have informed me in a different kind of way about how he's functioning in terms of, his proclivity perhaps for manipulation, deception, lying, etc. And so I need to know where he failed. And so I know that he falls in the average range on the Bell curve in terms of, reasoning and critical thinking.
Is your opinion and conclusion based solely on that personality test?
It is based, that is a test of reasoning and critical thinking, and no, it is not based solely on that. No opinion should be formed based on one thing. It needs to be a multi-method approach.
In the TSI-2, you know that Jason had anxious arousal and intrusive experiences. How do these findings support your conclusion that Jason's actions were likely reactive and premeditated?
In terms of supporting it, it basically builds a profile of how he's functioning. This is someone who likely has bad memories about something that has happened to them, experiences anxiety, which is worry or restlessness. Individuals like that may be quick to agitation. They may engage in behaviors to reduce tension, like using marijuana or alcohol. This is developing a profile of how this person is functioning daily.
How does your reliance on the empirical testing, using the tests that you did, and I guess the evidence and discovery that you received, ensure that your conclusions are not speculative?
It strongly ensures it because best practices indicate by the specialty guidelines of forensic psychology, which were adopted by the American Psychological Association in 2013, indicate that we should engage in a multi-method approach when it comes to evaluation assessment. And therefore, based on that adoption of those specialty guidelines, based on my work in the field of mental health since 2010, my work with inmates or justice-involved individuals since 2014 or 2015, it ensures me and it informs me that my opinion is not speculative.
Were your findings consistent with other peer-reviewed literature and established psychological principles?
My findings were consistent. Let me answer that in a different kind of way. The approach and the procedures that I used were consistent with any type of empirical research, for examples, etc. My findings or my opinion is something that I reached based on using those methods that were consistent with all empirical research that's available.
Were the methods that you used, the forms that you used, were those reliable?
Yes, those tests or forms, however you want to refer to it, have been used for years by psychologists across the nation. You can easily Google them and you can learn about a lot of these tests. And these testing are well developed. In particular, the personality testing sort was developed by Dr. Leslie Morey at the University of Texas, and he's still doing research on that testing. So it is very reliable.
Is it that your findings and conclusions that Jason Chen couldn't have formed the requisite mental state premeditation? Is that your opinion?
My opinion that it's highly unlikely that he formed the requisite premeditation.
What thing is that? The jurors ready for lunch? Yes, Your Honor. We'll let the jurors walk by, everyone's done. One more question? All right, go ahead.
Would any reputable forensic psychologist say with absolute certainty that a subject had the requisite premeditation or requisite intent, or is that something that goes too far beyond an opinion?
Saying absolutely certain is going too far beyond opinion. No reputable forensic psychologist or forensic psychiatrist should say anything with absolutism.
Thank you, Dr. Lewis.
Come on, General, you can send the jurors to lunch.
Yes, Judge.
Council protocol 2. Dr. Lewis, can you hear me? You might step off too. Got you muted. Can you hear me now?
Yeah.
Dr. Lewis, thank you so much. Mr. Watts will get in touch with you shortly to let you know how to proceed, how we're going to proceed in this case. I do thank you for your time this morning. Okay?
Absolutely. Thank you.
Yes, sir.
It's a privilege.
So the jurors just been sent to lunch. They've got Jimmy John's in the jury room, which means it won't take them very long. So they'll give them a little time to walk around. So this will be our lunch break too. Are there any matters you want to take up before we take our lunch break?
Yes, Your Honor, two separate issues. One has to do with the indictment. The state has indicted Mr. Chen for abuse of corpse. In that indictment, we listed all of the factors under the abuse of corpse statute, two of which inarguably do not apply and would be prejudicial if they were read to the jury. One of those is disentering a corpse that has been buried or otherwise interred. The other is disposing of, the other one is engaging in sexual contact. Neither of those are being argued by the state, so I would just request that I be able to leave those out when I read the indictment and only read the other two subsections that could apply in fairness to Mr. Chen.
Okay.
And then the other judge, so that the defense can object before opening statement, the state intends to introduce the suitcase that Ms. Pace's body was in during opening statement to avoid delay during opening statement where the jury has to go out. We figured we'd go ahead and disclose that now.
So you want to show the suitcase?
Yes, Your Honor.
Okay. Why is it common for evidence that's likely going to be admitted to be used in opening? Any objection?
Thank you,
Well,
Judge.
to the extent of all my past motions to suppress and all those, so.
You're not waiving anything.
Thank you.
Thank you, Judge.
All right, that clock says 12:20. Everyone will be back when that clock says 1:15. That's 55 minutes of lunch. What we're going to do is start the jury trial, bring the jury in. They'll be sworn over instructions keep it down. Court's still in session. You can leave, just be quiet. Still in session. What will happen is the jury will be brought back in. They'll be sworn.
I'll read the preliminary jury instructions to them, state with the indictment, we're going to open, you're going to call your first witness.
Yes, Your Honor. What time did you say? I apologize.
It'll be 1:15.